Sorry, my lord.
Yes, you are with who?
A.M. Bello, Esquire.
Yes, A.M. Bello.
Yes, Director Seafood Irrigation, Kwara State.
Okay.
I have with me and also B.L. Abdusalam and also B.L. Abdusalam, Principal State Council. Principal State Council. My lord, we appear for the 4th and 5th defendants. 4th and 5th defendant.
Yes, Clement Counsel. But has he filed?
They are filed, my lord.
Addresses.
Has the claimant served you with his written addresses? With his written address?
Yes, my lord.
Yes, he did.
Reply on point of law.
Yes, he did.
Which one is claimant replying on points of law? Did we hear the matter on the record?
Yes, my lord, we did. No, not on the record. We call evidence.
So why is claimant filing
my lord,
on point of law?
Yes.
My lord, what happened was that the claimant called a witness. The 1st, 2nd, and 3rd defendant called a witness. The 4th and 5th did not call any witness. So the claimant filed his address and served us. That's the 4th and 5th defendant before we file our own. So the reply on point of law is respectable.
Thank you very much. Thank you very much. That's quite in order and well understood. Okay, claimant is not in court.
Yes, my lord.
Adopt your processes.
Yes. With almost to my lord. My lord, the 1st to 3rd defendant filed the written address dated 17 December 2021, my lord, and filed same day, my lord. The 1st to 2nd defendant final written address, my lord, was dated.
Is this 2nd or 1st to 3rd?
1st to 3rd, my lord, defendant filed.
Yes, I've seen it.
Yes, grateful, my lord. My lord, yes. Also, when it was served on the claimant filed the written address on 29th day of December 2021. The claimant filed a reply to our address, my lord. In consequence of that, my lord, we filed reply on point of law to the claimant's written address. My lord, they said reply on point of law.
And a reply on point of law.
Yes.
On what date?
My lord, on 4th January, my lord. On 4th January. Yeah, 4th okay. January.
2022.
And was filed on the 5th. Well, it was dated 4th of January and filed on the 5th, my lord.
Okay.
Yes, my lord. My lord, we rely.
Good morning, my lord. My lord, we are. Good morning, my lord.
Yes, I don't think.
They will allow me that. My lord, we rely on the said addresses as our argument to this case, my lord.
You adopt and urge the court to do what?
My lord, and with what? So
urge the court to dismiss the case. The bad network. All right, thank you. Lanesuk.
Yes, my Lord.
Yes.
My Lord, the
Lord.
address of
Good morning,
my Lord,
Yes.
the address of fourth, fifth defendants, the five was filed
On 4th January 2022.
dated and filed the same day, 4th January 2022.
Yes.
My Lord, we adopt that file as our argument case. Your Lordship to dismiss the case in its entirety. My Lord, I want to seek your Lordship just to have one point.
The problem is even the network, I'm not hearing you well. I don't know, what do we do?
Maybe I think the other counsel can be muted so that when it is their turn to speak.
You say you want to do what?
I want to seek your Lordship's leave to make just one small point.
Please do, now that I'm hearing you.
On section 20, the contention in this case, section 26(5) of the College of Education Law, which is the principal law in contention in this case.
Yeah.
I want to respect.
Did you give me that law? Because you should know that I don't have that law in my library. I doubt if I have that law in my library. Thank you.
My Lord, the letter
36(5) of the College of Education Law.
Section 26 of 5 of the College of Education Law. Vis-a-vis the letter of termination. My Lord, it is submitted that there is a kind of regularity. There is a presumption of regularity. The removal of the claimant is concerned. He acts to the compliance with the section 20. Because it is an official act. And by virtue of section 168(1), the presumption is on the body is on the claim to give evidence to rebut that presumption.
Oh, thank you. I was even going to ask you whether it is an irrebuttable presumption, but you have cleared it.
It is a irrebuttable presumption.
One of the Evidence Act.
Section
168 Act, okay.
Sub 1. The body is to report is some way of which the claimant failed to do it in this case.
The burden is on the claimant to rebut the presumption, right?
Yeah, by way of which the claimant failed to do it in this case. He did not even attempt to do it. Well, I just prefer the case of
that will suffice. That will suffice because the network is fluctuating.
Okay, so
very good from your end. I'm not hearing you very well. But I think we are talking about presumption of regularity and the duty on the claimant to report. I may not need an authority from you, sir.
As God please, my lord.
Because
your lordship.
Right law.
Yes, my lord.
Thank you. Thank you.
My lord, I'm sorry to be late to court this morning.
Okay, good. Your appearance?
Yes, my name is Lanre Yahya.
Lanre who?
Yahya.
Help me spell it.
Yahya.
Yes.
Y-A-H-Y-A.
Y-A-H-Y-A. Yahya.
Yes, my lord.
No A after the H.
Recording in progress.
No A after
no,
the H.
it's just Y-A-H-Y-A.
Okay. For the claimant.
Yes, I have my number friend with me.
Okay.
H G Ibn Mahmoud.
H what?
G. The initials are H. G.
Yes.
Ibn Mahmoud. Ibn Mahmoud, my lord.
The network.
Ibn Mahmoud.
I have HG. Help me spell.
Ibn Mahmoud. Ibn IBN.
Ibn Mahmoud. Okay, I remember that name.
Yes, yes, my lord.
Yes, I remember the name. When I was saying we are used to Ibn, isn't it?
Yes, my lord.
Yes, yes. You are for the claimant. For the claimant.
Yes, my lord.
Okay, adopt your processes. Adopt your processes.
My lord, our final written address was filed on the 29th of December, 2021.
Yeah.
My lord, we filed a reply on point of law to the fourth and fifth defendant's final written address.
Yes.
That reply on point of law was filed on the 18th January, 2022.
On what you filed it?
18th January, 2022. Now, point of law.
Okay. Yes.
My lord, we rely on all the submissions contained in the final written address and our reply on point of law in urging my lord to grant the release as sought by the claimant in this case.
You haven't adopted them and you are relying on them.
My lord, we humbly adopt all our submission in the final written address and the reply on point of law.
You adopt your final written address.
My My Lord, we adopt our final written address.
Yes, I was just thinking it is after you adopt, you can tell me you are relying on all the submissions because
my
you are
Lord,
not going to have to read it anymore. It's just to once you adopt. Okay.
Yes. My Lord, we adopt the final written address and rely on all the arguments contained therein.
Yes, sir.
My Lord, we also adopt our reply on point of law.
You have.
As a copy.
Yes.
My Lord, I want to crave the indulgence of the court to make a few points, my Lord. To make a few points regarding the reply on point of law of the first to third defendants.
Okay.
Yes, my Lord.
These two points, sometimes they are the ones that will take all the time.
But my Lord,
you reply on point of law already and you want to make few points on it.
Objection.
My Lord, I'm sorry.
That, my Lord.
Let me hear you as sharp as you can, please.
My Lord, I just want to draw the attention of the court to the fact that the issue of the
on points of law by the that is first to third defendants. Yes.
My Lord, sir.
Let me hear him first. Let me hear him first before you can object.
My Lord,
you can't object to him without hearing him first. Please, let me hear him first.
My Lord, Counsel is preempting me.
Barry, yes, let me hear you.
Yes, my Lord. I was just saying the issue of the juristic personality of the first defendant of the counsel. That is the second defendant was not born out of any act in our final, and we have of the second defendant was raised in the reply of point of law in their paragraph 2.07.
The issue of the juristic personality of the second
juristic personality of the second was raised as a fresh issue.
It's not a reply.
It's not a reply. It's not a reply on point of law.
Any point
raised in our final written address.
Okay.
Yes, my Lord, I heard the court to discountenance all the submission in that regard.
Okay.
My Lord, we are grateful.
Constitute the ages of Evidence Act. The official act must conform it.
So if as a matter of fact, I see that the second defendant is not a juristic person, I should close my eyes to it simply because it was raised in a reply address.
My Lord, the point is that my Lord, the point is that if they want to make that an issue, they should have raised it as a preliminary issue, not as a reply.
I understand that is your argument now. I understand your argument. What I'm saying is that so if I find as a fact that he is not a juristic person, I should just close my eyes to it and say, well, he didn't complain.
My Lord, we would not have been hard as to our position on that point. It is prejudicial to us.
Is it when I hear you on the juristic person personality of the defendant that I will be able to find out, or is it a matter of law?
My Lord, it's a matter of
personality of the second defendant. Is it a question of fact or a question of law?
It's a question of law, my Lord.
Okay. So, because I didn't hear you on the issue of law, it's all right.
As it is, our arguments in that regard.
Yes, I understand. My point is to understand your submission.
Yes, my Lord.
Yes, that's all right. Yes, counsel, you were itching to stop him. Has he said anything that he ought not to have said?
The issue of juristic person Somoto.
Yeah?
My Lord, I said you can even raise juristic person Somoto.
No, what he's saying that no, his argument is that it will violate his right to fair hearing. That the fact that you raise it in your, it is in your reply on point of law, which he didn't raise. I wonder how he could have raised issue of distinct personality of second defendant in the first place, but that for the fact that you are raising it in your reply, it will violate his own rights. And I was thinking, okay, having given him the chance now, utilize the chance to argue that it will violate, I should not look at it, instead of telling me why it is a juristic personality. I've given him that chance.
Yes,
it's a reply of point of law, and he makes his reply to it. But his reply, instead of what he tell the court, no, it's the juristic personality because of this or that. He doesn't want to utilize that opportunity. Instead, I should just close my eyes. I should not look at the merit of that argument.
My Lord.
Yes.
My Lord, I take the hint of the court. I want to refer the court to the law of the first defendant, College of Education and Learning Law, Section 5 thereof, Section 5 and 6.
Yes, Section 5.
Section 5 and Section 6 of the College of Education and Learning Law.
It does what? Or it says what?
It establishes the second defendant. The second defendant, the creation of the law.
Thank you.
That gives it the legal personality, the juristic personality.
Thank you very much. That is the better way to argue these things, because
my Lord, I'm very grateful.
I can swear man is not a legal personality.
Yeah.
I strike out his name. You understand? Then it will be left for you to go to Court of Appeal, and now you will remember there is a law that I could have relied on to say it's a legal personality.
Lord,
when that law, you could have cited it to me here and now.
I'm grateful for the indulgence, my Lord.
Thank you. I will look at the law.
For the indulgence.
I will look at the law.
As the court pleases.
So please, all of you, it will enrich our library here. Next time when we have issues about College of Education, Kwara State, we will not ask for the law.
We will supply it to the court.
Case adjourned for judgment on a date to be communicated to parties.
As the court pleases. I wish my Lord a wonderful day, sir.
Thank you. I see today is a very special day, 2022. 222022. All right, gentlemen, you are welcome, and I wish us a prosperous new year.
Thank you, my Lord. Amen.
You're welcome.
Thank you, madam.
We will all leave the meeting.
That I put my phone on.